And our last case of the day is Howard County, Maryland versus Russell McClain, number 1166 of the 2020 term. Ms. Gurma, am I pronouncing your name correctly?
Yes, Your Honor.
Okay, you go ahead. You've reserved 5 minutes for rebuttal.
That's correct, Your Honor. Unless I finish sooner, then I'll reserve any remainder.
Whatever. Yes, sure. Go ahead.
That's correct, Your Honor. May it please the court, Seika Gurma on behalf of Howard County government. CB9 is not a special law. The circuit court's declaratory judgment invalidating CB9 as a special law in violation of Article 3, Section 33 of the Maryland Constitution was legally incorrect. Appellant therefore comes before this court asking this court to reverse the circuit court's decision to repeal a valid legislative enactment of a duly elected legislative body. Under Maryland law, legislative enactments such as CB9 are given a high degree of deference when subjected to judicial review and are presumed to be valid. CB9 was entitled to such presumption and deference and should not have been repealed as a special law. The circuit court misapplied the legal precedent concerning special laws when it invalidated it as a special law. A special law is one that relates to a particular person or things of a class, as distinguished from a general law which applies to all persons or things of a class. And that's 113 Maryland 179. Judge Friedman, in his treatise on constitutional law, stated that the prohibition against special law was really aimed at preventing, quote, influential people from getting an undue advantage over others through the enactment of private acts. Pursuant to the Court of Appeals, private acts are acts for relief of a named party or providing for individual cases. And that's not what CB9 is. It didn't name a private party, nor did it provide for an individual cases. Over time,
okay, counsel, is there anything in the record showing that there are other private schools that are in the same sort of situation with regard to pipe stem lots that whatever the school is, Glenelg Academy or whatever it's called in this case?
So, Your Honor, the record is clear that the county identified at least, and we're not certain that there certainly could be more. There are at least 30 private academic schools approved as a conditional use in the county.
Sure, but how many of them have these adjacent pipe stem lots?
The county wasn't able to determine that, but I don't think that is what's critical.
Why couldn't the county have determined it?
It would have been, well, the burden here, Your Honor, is on the party challenging the law, not on the county.
And they've said that there's no other schools, private schools with that same scenario, that Glenelg Country School is the only one that qualifies under this legislation.
Your Honor, but what the statute does here, though, with regards to the pipe stem portion, is it clarifies how an authority or the hearing examiner should treat pipe stems when considering private academic schools which are applying as a conditional use. So that's applicable to any party which may have a pipe stem. And what's important—
But are you saying it's insignificant that the only school that would qualify is that there's only one school who sought the change? Are you saying that's insignificant or just not dispositive?
No, what I'm saying is it's impossible for anybody, including the county, and this court should not make a determination that only Glenelg Country School is the only one that could benefit from these provisions.
Well, you said there's 33. Was it in the record below, or are they just asserting this on appeal that only one of those 33 private schools would benefit from this?
Well, I believe what was said in the court below from the appellees is that they made an independent determination based on the list of at least the 30 private academic schools identified by the county, that only one of them had a pipe stem, which could potentially come under the purview of CB9.
So
but I think,
given that you said they had the burden, but given that, was there an obligation on the county to rebut that if it wasn't true?
no, because the law states otherwise, Your Honor. It's very important to consider what the law says with regards to this fact, which is that merely because a person or entity is not susceptible to enumeration, so just because you can't identify necessarily who may come under the purview of the law, does not mean that the challenged legislative enactment has no effect on them. And that's in MDE versus Days Cove Reclamation. And I believe that's a Court of Special Appeals case. And I could give the court that citation.
We have that citation.
Okay.
I guess my question went more towards, I understand, that's, the county's position, but my question was, are you disputing that this legislation only affects at this time Glen Elk Country School?
Yes, I think that the county cannot concede that this statute only applies to Glen Elk Country School, because
So if you're going to dispute that, do you need to show who else would be covered under this bill?
well, I don't believe that that's what the law requires. And specifically with regards to the site that I just gave with regards to what the Days Cove Reclamation case, this very court state.
Council, let's talk about Days Cove, because in Days Cove, that had to do with a restriction on certain kinds of agricultural uses within a certain number of feet or miles, I forget which, of the headwaters of the Corsica River, where the Days Cove project was located. But it also identified the headwaters of another river over in, I think, in Prince George's County. So one of the things that separates the statute in Days Cove is that there were actually two identified areas that the statute would apply to, but we don't have that in this case. So this statute's drafted differently.
Well, this statute applies to any private academic school currently approved or to be approved in the future throughout the county and the various zoning districts that come for a conditional use application before a hearing examiner. And Days Cove is actually very relevant to this case and very comparable in the fact that Days Cove argued that since they had the only application for a rubble landfill in the affected area, that the statute had the practical effect of only burdening them, which is really the same kind of argument that appellees are making here. And the court rejected that argument and said, no, you have to look at the face of that statute. You have to look at the terms and provisions of that statute. That statute didn't name Days Cove and applied broadly to any entity that wanted to construct or operate a rubble landfill near a waterway. So that's exactly what we have in this case. Although Glen Elk Country School may be the only one known at this time that these provisions may apply to, does not mean that this is a special law. And there's other case law that says exactly that, including Kenwood Gardens condominium versus Wayland Properties. In that case, it was very similar to Days Cove, very similar to the facts of this case. And in that case, there was a PUD application before a zoning authority, and the legislature amended the compatibility standards under the zoning regs for PUDs, and it applied really to Wayland Properties. And what the Court of Appeals said in that case was, well, just because this statute applies only to this entity at this time does not make it a special law, because under its terms and provisions, it could apply to many more PUDs that apply for approval in the future. And they did the same exact thing in that case. They amended the zoning regs that precluded or that modified the compatibility standards. So the fact that what's important here is, what do the terms and provisions of CB9 state? Does it apply broadly to all private academic schools that may apply for conditional use application? Absolutely. Does it name any party? No, it doesn't. And those are the factors, particularly those outlined. And does it serve some important interest? And the record.
Okay, counsel, why are there are, I'm confident, any number of churches and other private entities located in Howard County that are next to pipe stem lots. Why is it that private schools get this particular favorable treatment as opposed to a church or a hospital or a mental health center or a retirement home or any other organization that provides public services?
Your Honor, I think that's an excellent question. And the
Well,
record.
that's why I asked it.
Okay, and the record answers that question very clearly. At the time that Glenelg Country School applied for this zoning regulation amendment, filed their petition for the zoning regulation amendment, they proposed that the amendments that they were proposing would be applicable to all conditional uses in the county. Now, the county council considered that, and the county council exercised legitimate discretion and judgment and said, no, we don't want these provisions to apply to all 64 plus conditional uses that range from wineries, gun ranges, and landfills, because we want to limit it to just academic schools, despite the fact that Glenelg had proposed that it be applied to all conditional uses, because they wanted to prevent unwieldy or unintended results happening from passage of this bill. So they had two public hearings, 2 work sessions. They discussed this at length, and they amended the proposed zoning regulation petition by Glenelg to say it would only be applicable to private academic schools. And Your Honor, Maryland case law specifically says that's a permissible thing for a legislative body to do. By that, I mean, making a proposed law specific to a single category of land uses is permissible because, quote, legislative bodies are not required to attack all aspects of a problem at the same time. Rather, the legislative body may select one phase of a problem and apply a remedy there, neglecting for the moment other phases of the problem. And that's also from Days Cove reclamation case, and that was at 284. So legislative bodies are entitled to exercise legislative judgment and discretion in making these laws. And what's even more important is that the case law is very clear that courts have to be very careful when overriding the legislative judgment or discretion of a legislative body. And this is a Court of Appeals case, quote, a large discretion is necessarily vested in the legislature to determine what the welfare of the public requires and what measures are necessary to promote it. That's Edgewood Nursing Home versus Maxwell 282, Maryland 422 at 426. In other words, to find fault with a law is not to demonstrate its invalidity. It may seem unjust, yet be free from judicial interference. So the court should not be swayed to believe that CB9 is a special law merely because the legislative body limited it to private academic schools which apply for conditional use approval. That was something that was legitimately within their discretion, and they decided to say, no, we only want to make this applicable to private academic schools because of the diversity and numerosity of conditional uses in the county, and we want to avoid unintended consequences from passage of this law. I think at this time, I will reserve the remainder of my time. I think I'm just going to add 1 minute to my rebuttal.
Okay, that's all right, counsel. Mr. Giel, am I pronouncing your name correctly? You have 20 minutes, sir.
That's correct, Your Honor. Good morning, Your Honors. Grant Giel on behalf of the appellees. What we have before us today is, in my mind, a relatively simple legal analysis. The facts in the record are, despite appellant's suggestion to the contrary, wholly uncontested. Both parties motioned for summary judgment on joint operation of that belief, and the circuit court decided accordingly. The central question at hand is whether the contested bill, CB 9/2020, comports with the analysis of special laws as detailed in City Services Co. versus Governor and subsequent cases. First, however, I would like to set the stage by iterating and reiterating the factual background of this case. We have before us a private academic school called Glen Country School. The school owns 2 parcels of land in Howard County. Bisecting those parcels is a series of utility pipe stem easements by a collection of homeowners, pipe stems by a collection of homeowners who live adjacent to Glen Country School. In 2007, and amended shortly thereafter in 2008, GCS entered into an easement agreement with the prior homeowners of those pipe stem easements. Later, the latter half of the 2010s, GCS wanted to expand its build out. It planned to develop buildings without.
Can I stop you right there for a second? Are these pipe stems strictly for utility access, or are they also for travel back and forth?
They're too small individually for anything other than utility. Presumably they could make a driveway if they all combine them in the same way, but at the moment they are using them for utilities.
Okay, thank you.
GCS planned to develop these buildings without regard to interior setback requirements of the pipe stem easements. It submitted several plans labeled before the zoning hearing examiner as Petition 2, CP2, CP3, and CP4, all on the record, which were all denied by that hearing examiner. The hearing examiner granted Petition 1 and CUP1 to the extent that they granted the building of the wastewater treatment buildings, no subject to the standard setback requirements for all conditional uses. The ZHE also required that GCS properly collect signature authorization by the fee simple landowners of the pipe stems in accordance with Howard County zoning regulations and the conditional use application procedures, particularly Section 4B of the conditional use application form. GCS did not like this. GCS believed, in accordance with its easement agreement, that it had an unrestricted right to circumvent the HCZR and conditional use requirements, and that the easement agreement itself should act as a stand-in for signatures from fee simple landowners. The zoning hearing examiner disagreed and required a court order to state otherwise. At this point, GCS was in a situation where it wanted to expand, but the law would not allow it to do so in the manner it sought. So instead of comporting with the law, GCS moved to change it. They filed ZRA 188 before the planning board, looking to get the HCZR amended in their favor. The planning board reviewed their proposition and recommended disapproval on much the same grounds as the ZHE. ZRA 188 then proceeded to become CB 9/2020 before the County Council of Howard County, the primary legislative body. What did GCS want? It wanted to not be subject to signature requirements if it had an exclusive dominant easement over fee simple land. It wanted to not have any setback requirements for interior setbacks in a circumstance like its own where it owned both parcels on either side of the setback line. It wanted pipe stem easements to be treated as single easements. It wanted the hearing authority listening to the variance petition to be obligated to proceed in the case where the easement agreement was, in their words, consistent with the variance. The County Council reviewed this petition. The County Council discussed it and affirmatively stated, as shown in the record, that they were worried that it would be an illegal form of spot zoning. The County Council nevertheless persisted. They produced a bill that would amend the conditional use section of the HCZR, Section 131, in precisely the manner that would benefit GCS. They rewrote the law so as to oblige a zoning authority to proceed in precisely the circumstances contemplated in GCS's dispute. The law would only affect a private academic school approved by conditional use, which specifically owned multiple adjacent parcels, and those parcels intersected with pipe stems, and the pipe stems were subject to an easement agreement, and it was an exclusive easement agreement, and the school was applying for a variance, and the written authorization required to proceed could be in the form of the same easement agreement, but only again for private academic schools. The County Council made no attempt to explain its position to make this particular carve-out beyond a general statement that they may be afraid of potential unforeseen consequences of amending the conditional use regulations generally. It provided no explanation for why this was even necessary for this particular type of use, or why it wasn't necessary for other conditional uses. In sum, a single entity that was denied its desired boons under the law approached legislators and got them to change that law in precisely the manner that would allow it to circumvent that prior denial in a wholly arbitrary manner.
But do you dispute that it could apply to a future private school if it met these qualifications? So it's not only Glen Elg that would be covered if another school met these circumstances.
I could conceive of a hypothetical future circumstance where all these things could come about. I consider it to be extremely unlikely, and given that the county has produced its records of 3 decades of presently approved conditional use academic schools, that
But
never.
new schools are being built all the time.
Yes.
And how do you distinguish this from the raised versus Prince George's County, excuse me, in which it authorized any sports stadium or sports arena in Prince George's County, and there was only one that would qualify, but because the wording would apply generally, and any new sports stadiums that were eligible, it could apply to, it wasn't a special law. How is this different?
I think the difference is in the particularities of the cases. There's a difference between saying a sports stadium will get these benefits and saying these benefits will apply to a private academic school in these particular circumstances. The conflation of all these different changes that they made really only apply particularly in circumstances where the private academic school has to have 2 separate parcels, and there has to be some sort of easement moving through, and they have to have specifically an exclusive easement agreement, and those easements contemplated in the ordinance are also, if they're pipe stems, compiled all together, and they would need to be subject specifically from these setback requirements. There absolutely could be some hypothetical circumstance in the future where some other plot of land at some point gets those 2 parcels with that intersecting line, and et cetera, et cetera. I think, and I will state further later, if you allow me, that I believe there's a difference between the analysis of a benefit and the analysis of a burden for future uses, and that the analysis of a benefit should be more stringent than the analysis of a burden. But yes, I can see that it is hypothetically possible for some school in some capacity to possibly build like this. I don't think it's ever going to happen in any reasonable period of time.
Why don't you address the benefit versus burden analysis? And my view is, I'm looking at Days Cove, excuse me, which I know imposed a burden, it imposed a prohibition. And then in the CGI versus whoever, the state of Maryland case, also imposed actually a prohibition. I don't remember candidly under the facts of the Montgomery Ward case, which is the sort of the start of the recent body of case law on special legislation in Maryland, whether Montgomery Ward, whether that statute imposed a benefit or a burden. So if to sort of frame your analysis, if you could address those.
Well, sir, I would have to ask, what's the actual question here? What I think is the difference between benefit and burden?
What or do the cases treat allegedly special statutes that provide benefits more restrictively or less restrictively, or the same as allegedly special legislation that impose prohibitions or burdens?
Well, I think the seminal case here would be Beauchamp versus Somerset. I could provide the citation, but it's in our brief. And that was a circumstance where they were considering a law that would only benefit one person, but could one entity, but could hypothetically benefit other entities in the future. And in prior instances, whenever you had cases where it was a detriment to that other entity that could potentially be in the future, the underlying rationale of those cases was a public policy matter, that we had instances of like a tax that was applied to a particular type of entity. And that entity might be the only entity in question that tax would apply to right then, but the general legislature would want to disincentivize that use via that taxation for future uses. So the court's rationale is there is a legitimate reason to try to prevent future acts from occurring for these other future uses whenever you were trying to stop that use, whenever you were trying to hinder it in some manner. Whereas for the benefit, I suppose you could come up with a circumstance where you say that they're trying to create a situation where it's more advantageous to create this particular type of use. But the cases that we have before us have never contemplated that. They've contemplated a public policy reason to make it so that a burden that travels into the future is less stringently analyzed because there is a good, very obvious, legitimate reason for a general legislature to try to stop future uses when they see the first one show up.
Okay, go ahead.
Sorry, I'm trying to remember where I was. Yes, okay. So we have this one particular entity that is trying to get this one particular benefit, and nobody else is going to get this benefit at this present time. Special laws, as opposing counsel stated, are forbidden by the Maryland Constitution. And appellees believe that this council bill to be such a law, and they filed for declaratory judgment. The appellant county opposed the motion, moving for summary judgment in its favor. Appellees responded with their own motion for summary judgment. When appellees responded with their motion for summary judgment, they produced a series of documents from public government websites, Howard County GIS maps, SDAT records, Maryland land rec records, and accompanying easement agreements, all speaking for themselves by their own mere existence, conclusively demonstrating as a matter of uncontested fact that the law would only benefit GCS. The appellant never argued against these documents in its briefs, never withdrew its motion for summary judgment on the basis that it maintained a factual dispute over those documents. The only time that they mentioned anything in the lower court was that they weren't ready to concede at this time. Wholly inappropriate for a summary judgment hearing. If you're going to say that you have a factual dispute, say it. But they did not at any point actually argue that these documents were in any way inaccurate, and they were right there for the court to review, and the court incorporated itself. Obviously, this court's review is de novo. You don't need to take the circuit court's analysis, but the factual circumstances are striking and uncontested there. That we had a summary judgment hearing. They produced their affidavit of the available schools that they knew of. We produced the clear public documents showing that this law could not possibly apply to anything else other than GCS at the present time, hypothetical future uses notwithstanding. And as a result, the school was the only one that was going to get the benefit. So what we have here is not a factual dispute. We have a question of law. And City Service Co. has developed a 6-element test in determining if a law is a special law. 1, whether that legislation was intended to benefit or burden a particular member or members of a class instead of an entire class. 2, whether the legislation identifies particular individuals or entities. 3, whether a particular individual or business sought and received special advantages from the legislature. 4, whether the legislation's substantive and practical effect, not merely its form, show that it singles out one specific individual or entity for special treatment. 5, whether the legislatively drawn distinctions are arbitrary and without any reasonable basis. And 6, the public interest underlying the enactment and the inadequacy of the general law to serve that interest. We say, based on many decades of jurisprudence, that these elements are somewhat combined and that you can really reduce them to 4 more particular questions. 1, did the law benefit or burden a specific entity either implicitly or by name? 2, did they seek out that special advantage? 3, did the law and its practical effect show that only one party would benefit with no reasonable basis? And 4, was there a public interest for a special evil as the law describes it? There can be no reasonable dispute that this bill violated question number 2. GCS clearly had been stopped in its endeavors by the law, and it underwent the process of rewriting that law so that it wouldn't be stopped anymore. This is, in fact, entirely undisputed.
Well, if the hearing examiner's determination was that the setback requirements apply to easements, utility easements, right?
Yes.
That was what
they believe that setback requirements of the conditional use process generally apply to these easements. Yes.
Okay, so if you have a utility easement that bisects a property, what is unreasonable about saying that you don't have to comply with the side yard or property line setbacks there? It's an underground. You can't interfere with the easement itself. But why can't you build up to the edge of the easement?
I don't think it's a matter of
What's the
reasonability.
public, no, what's the public policy that's suggests that that's unfair or inappropriate or unreasonable?
Yeah, I don't think that it's a matter of reasonability. I think that had they properly gone through this and the general legislature decided that, you know, we need to change this, we have the public policy reason, we don't think that we need to have the setback requirements for internal easements, they could potentially do so. But I don't think that it's a matter of reasonability there. I think at the time, the law did not allow this, and the zoning hearing examiner reviewed that law and they said, law doesn't allow this. And then the facts unfolded such that GCS said we would need to change this law.
Yeah, so you haven't really. Okay, go ahead, Council. Go ahead.
I may be able to answer it more generally with public policy statements, but there could be a general public policy reason to remove this restriction. It wasn't exemplified or described in any meaningful way in the record that we had before us. We didn't have it.
So your client is a neighboring landowner.
Series of owners,
several
yes.
of them. Do they assert an injury here?
Not in this present case. I'd say that they would assert a general injury, but we didn't make that part of the case.
And it doesn't need to be for you?
I don't think it needs to be. I think they have the general standing and that this could potentially affect their utility easements with the build out, and it could prevent them from properly using those easements. We didn't make it an issue.
So they use the pipe stems for utility as well as
the uses in question, the properties in question are connected to a main public road by a private road only. So without the public utility easements, they wouldn't be able to have access to things that the county would otherwise be able to provide. Had it been, in my mind, a relatively meaningful question as to whether or not the injury was needed here, we would have made that part of the case. We did not do so. We had the general standing that this was going to affect them. We weren't seeking an injunction
because they're neighbors. Because they're neighbors.
Because they're. I'm sorry. Could you
if someone filed who lived two blocks away or 2 miles away.
Well, yeah. They have general property owner standing anyway, just from an impact.
Okay. All right.
The question of whether or not the law benefited or burdened a specific entity, in my mind, is clear that it did. First, as I described before, it's important to note benefit and detriment. We've talked about that already. And I don't want to reiterate it at this point. I think that we specified it well enough. But with a benefit, you don't have the considerations of future uses at hand, unless you're really writing the law in such a way as to really drastically incentivize something. Maybe you could construct a law that would really incentivize a particular type of building, but that's not what's happening here. This is after the building's already been built. What can they do on their land? It's not giving them a new incentive to build out more public academic schools. Sorry, spam call. So the facts here are uncontested and unobjected to. The all identified conditional use schools in the county by the county's own affidavit and by public government documents clearly do not benefit from this law except for GCS. And I don't believe there's any plausible circumstance that any of them could do so. In the future, maybe something hypothetical could happen, but the narrow circumstances of how the law is written prevent it from happening in any reasonable period of time. I would ask, Your Honors, am I going to be cut off at precisely 20? Or are we extending for questioning?
Go ahead, Counsel, with your
okay. So I think we arrive at the third question here as to whether or not the law had any reasonable distinction for the singular benefit. I say no. I say that the county council provided no rationale beyond a generalized, maybe this will affect other types of uses. It's hardly good cause to say that a law shouldn't be generalized, especially if it's trying to fix something that is apparently a general problem. If it's supposed to fix a special evil as suggested by appellant, then it's simple and obvious to fix it across the board. If appellant's argument about density is legitimate and they were worried about high density uses, could have specified uses in accordance with density. We would still argue even then that the other circumstances of the case would mean that it's singling out GCS, but at the very least, it would be much more difficult for us to demonstrate, as we did in this case, that no present uses could benefit. There could be hypothetical present uses, and the amount of plots we were looking at would be so numerous that we wouldn't be able to analyze it properly.
Counsel, how would you respond to your colleague's argument that the restriction to private schools was a mechanism to avoid unintended consequences? She didn't use that terminology, but that's in effect what it comes down to. That this statute should be viewed as an experiment to address the problem of how zoning regulations apply to properties bisected by underground utility easements.
I'd have to say that I don't see what the consequences would be. They argue in their briefs that this is already something that's allowed by right uses, and that it was an oversight in the legislation that would prevent conditional uses from having the same benefit. Of course, I'd say that a conditional use is different than a by right use, and that you shouldn't have the same allowances for conditional uses, but that's what they argue. I would say if you think that there's a problem with internal setbacks, and you think that it is not going to be an issue, it's not going to impose any problem on the pipe stems in this instance, or on any other, let's say, non-pipe stem easements, because you could potentially, I guess, have an actual other plot of land and then it's separated by 50 feet or something. If that was actually an issue, then you would think there would be an issue for everybody, and that everybody should be able to benefit from this law, and that especially if they're going to argue that there's an exclusive easement and that the other person isn't even allowed to contest this in the first place, that they wouldn't have any arguments to go off of. That it would just be we are fixing an oversight in our laws. This should be what conditional users should be allowed to do. This is our public policy reasoning.
Okay.
I would still say.
Okay. Thank you. Judge Grafe, Judge Atkins, any further questions of Mr. Giel?
No.
All right, then Ms. Jima, you have your 6 minutes of rebuttal.
Okay, Gurma, Your Honor. There is one thing that I need to clarify, which there is clear misunderstanding about what the law does. And that is that these easements don't need to bisect a property in order to be applicable to a private academic school, which applies for conditional uses. Each amendment that came about as a result of CB9 is a standalone. So let's go through what the statute actually does very quickly, Your Honors. Number one, it provides clarity and guidance for a hearing authority on how to handle a exclusive easement that a private academic school may have when applying for a conditional use. That easement doesn't need to bisect the property. It's just any easement. Number two, the hearing authority, CB9 allows the hearing authority to vary setback requirements applicable to conditional uses on a case-by-case basis, which is what the zoning regulations do for uses by right. And the Department of Planning and Zoning, who gave a technical staff report as required by the code concerning this zoning amendment, stated that that is a wise thing to do, that conditional uses, just like uses by right, a hearing authority should have discretion on whether or not to vary setback requirements to ensure optimal development of land. And number three, the CB9 was amended to permit childcare centers and nursery schools as an accessory use to private academic schools. And DPZ also stated that that was their reading of the regs anyway. So this argument by appellees that all these things would need to apply, i.e. that an easement would have to bisect a property or any other, the other conditions that are present.
Counsel, I think in fairness to your colleague, I was the person who introduced the term bisect into this dialogue, but go ahead.
Well, Your Honor, it is also used in their brief. So I think you may have gotten it from the brief, but I just want to be clear that CB9 does not require an easement to exist on the center of a property or any of the other special
Well,
conditions that are present.
let's say the easement exists on the extreme boundary line of the property, which is a far more common situation. There, the side lot setback, property line setback would apply, right?
I don't know that I could say that conclusively, Your Honor. I mean,
Well, let me put it this way. Does Howard County measure in the situation where there's a utility easement that runs along a property line? Does Howard County measure the side setback from the property line or the boundary of the easement?
it'd be difficult for me to
Or does it depend district to district, use to use?
I think it really depends, and you'd have to look at the specific zoning regulation to make that determination. But that's precisely the point here, Your Honor. They were attempting to provide more guidance for the hearing authority when considering these issues, because the current zoning regulations did not address how exclusive easements were to be considered by a hearing authority when there was a conditional use application. The current zoning, what happened in this case, Your Honor, was that the conditional use application by Glenelg Country School raised questions that were not answered by the zoning regulations. And Glenelg Country School, pursuant to the county code, section 16208, filed a petition to amend the zoning regs to answer those questions. And all the provisions that were ultimately adopted apply universally to all private academic schools that apply as a conditional use. And the record is very clear why the legislature, why the Howard County Council made it only apply to private academic schools as well. I also think that it's really important for us to consider or to understand that the complicated history of Glenelg Country School and their conditional use application does not change the analysis here. Their history, let's assume that the Howard County Council passed these amendments, zoning regulation amendments, in order to assist Glenelg Country School in passing. That still wouldn't make CB9 a special law, because CB9 is very broad and general. And
well, the subjective state of mind of the legislature, the legislators, is irrelevant.
Exactly, Your Honor. That's the point I'm getting at. Exactly, Your Honor. The legislative motives of the legislative body is totally irrelevant to the determination of whether or not CB9 is a special law.
The motivations of individual members of the legislature.
That's correct, Your Honor.
Irrelevant.
That's correct. And so that's why I wanted to say, Glenelg Country School's complicated history before the hearing authority or their current appeal to the Board of Appeals is totally relevant. What we have to look at, what the court should look at, is the terms and provisions of CB9. Does it apply broadly? Yes, it does. Does it apply to all private academic schools applying as a conditional use? Yes, it does. Did it provide some did it try to fill some public policy or public interest? It did. It created answers in the zoning regs on how to treat exclusive easements, how to deal with setbacks as it pertains to exclusive easements, and what are accessory uses. And these apply broadly. And I'd like to just say, I know my time is almost out, but I think the most important, one thing that I'd like to really end my argument with is by saying, this is really about the easement agreement that these homeowners signed with Glenelg Country School. This is just a thinly veiled attempt to undermine the impact of those easement agreements.
Counsel, at this point, you've exceeded your time, which is one thing, but you're also raising an argument in rebuttal that you didn't raise in your your first presentation to the court, which is a different issue. So I'm gonna unless there's are questions from Judge Grafe or Judge Adkins, I'm going to stop the oral argument at this point. You're done, Mr. Giel. I will say that this is an interesting case, and I thought this case was well briefed and argued with a great deal of enthusiasm and conviction by counsel for both parties, and I commend both of you. Now, that's just me speaking. I'm not speaking for the rest of the panel. And on that note, we will submit this case for a decision, and we will adjourn for the day. Thank you.